Hi everybody and welcome back. Today we're going to be moving away from policing and law enforcement and we're going to make our way towards the courts. We will begin by talking about the American court system and how cases move through beginning at the trial court level. We will also focus on the appeals process at both the state and federal level. With that being said, let's get started. First, as you can see from this slide, the American courts are founded on a dual court system. This means that you can be tried at either the state or federal level, and in some instances, you can be tried at both levels given the specifics of your individual case. Court cases begin at the trial level and move their way up through the appeals courts. For instance, if you are tried at the state level, you will continue to appeal at the state level. This is the same for the federal system. The two systems never overlap, with one exception, which is of course the Supreme Court of the United States. I will continue to call the Supreme Court of the United States by the acronym of SCOTUS for the rest of this lecture. If you exhaust all of your appeals at the state or federal level, then your last option is the SCOTUS. If they decide not to hear your case, then you have no more appeal options available to you. Most frequently, individuals encounter courts of original jurisdiction and appellate jurisdiction. When we talk about jurisdiction in a general sense, it refers to a few things. First, where is the location of the trial venue? If you commit a crime in Texas, then they are not going to try you in Arkansas. This goes for the federal level as well. You will be tried in the location that you commit the crime in. Although there are a few exceptions for change of venue, but those are very difficult to achieve, and defendants normally try to achieve them in order to remove the bias that is probably against them in the surrounding communities and the media. But as I said before, this is typically a very difficult accomplishment to achieve. Second, when we are referring to jurisdiction, we have to ask ourselves, what is the appropriate level for the case? Is this a state or a federal crime? Are you appealing your original sentence? Is this a bankruptcy case or is this a civil case? The courts have appropriate jurisdiction for all of these questions. First, original jurisdiction refers to where the case began. So where was your trial held if you went all the way to a bench or jury trial? Second, appellate jurisdiction refers to the court to which you appealed the decision made in the court of the original jurisdiction. So if you were found guilty in the court of original jurisdiction, then you would make your way into a court that has appellate jurisdiction. This level of court is not going to review whether or not you are really guilty or not guilty, but instead the appeals court is going to review your case for administration or procedural issues that take place, such as ineffective counsel or coerced confessions or inadmissible evidence that was entered during your trial in the court of original jurisdiction. Moving on, let's focus on special jurisdiction. This refers to cases that have to make their way through places like bankruptcy court or often involve patent violations. When we talk about subject matter jurisdiction, we have to tie in courts of special jurisdiction. This gives the court the ability to hear a particular kind of case. For example, bankruptcy courts can only be heard in bankruptcy cases. These two are very similar. You end up seeing a lot more subject matter jurisdiction taking place at the federal level than you do at the state level for sure. So speaking of the federal courts, let's shift our focus there for a while. There is a uniform structure to the federal court system that occurs no matter what state the actual court is located in. Within the federal system, the courts are trying and reviewing cases that violate federal statutory law, but also that contain issues that directly involve the United States Constitution. You'll see that the district courts are the lowest level courts and serve the court of original jurisdiction for all federal crimes. The highest court in the federal system is of course the SCOTUS. It is comprised of 9 justices who must vote in a majority manner in the cases that they review. The SCOTUS begins their session in the first Monday in October every year, and their sessions last until late June or sometimes even early July when they give their rulings for a number of cases that they hear during the session. If you're interested in learning more about how the SCOTUS and the individual justices, specifically how they rule in their deciding cases, visit the SCOTUS website where you can see the breakdown of recent notable cases. This slide shows the hierarchy of federal courts, where cases originate and where they are appealed. Criminal cases for civilians will originate in one of the 94 district courts. That will be the court of original jurisdiction for federal criminal cases. Defendants can then appeal to one of 12 United States Circuit Court of Appeals, which has appellate jurisdiction for the federal court system. Two factors determine jurisdiction of federal district courts. The first factor, as we've discussed before, is subject matter jurisdiction. Federal district courts have jurisdiction over cases involving federal laws, treaties with foreign nations, interpretations of the Constitution, and maritime law, or laws of the sea. The second factor involves the parties to the case. Federal district courts have jurisdiction in cases involving ambassadors or other foreign government representatives, two or more state governments, the United States government, citizens of different states, a state and a citizen of a different state in dispute, citizens of the same state claiming lands under grants of different states, and a state or its citizens, and a foreign country and its citizens. So let's now move to the appeals process, and let's begin with the Circuit Court of Appeals. Once a case is decided in the court of original jurisdiction, or the district court, either the defendant or the government can choose to appeal the case within the Circuit Court of Appeals. But that does not mean that the defendant can try and overturn the ruling simply based on evidentiary factors that would suggest that he or she is not guilty. Rather, the defendant would have to try and get the ruling overturned based on a procedural issue, as we discussed before. Dependent on where the case originated, there is a court of appeals that will hear the case at the mid-level of the federal structure. As we saw on the last slide, there is a Circuit Court of Appeals that oversees criminal, civil, and military trial courts. There are 13 courts of appeal within the United States. This map shows the location of all 13 Circuit Courts of Appeal for the federal judiciary. We have already encountered this map once before in this semester, but as a review, this is a map of the 12 U.S. Circuit Courts of Appeal, plus one located in Washington, D.C., which is also serving as a district court for that area. You'll remember that Texas is part of the Fifth Circuit Court of Appeals, which is located in New Orleans. Turning to the SCOTUS is known as the Court of Last Resort. It is the highest level appeals court at both the state and federal level, and the only court where jurisdiction overlaps for both state and federal cases. The SCOTUS hears appeal cases from lower federal courts and anything from state courts which question a constitutionality issue. The United States Supreme Court is composed of a Chief Justice, who is currently Justice Roberts, 8 associate justices, and each member of the United States Supreme Court is appointed for life by the President of the United States and is affirmed by the Senate. Applicants can petition the SCOTUS all the time, but it's very rare that the SCOTUS will actually hear a case. If 4 justices agree to hear a case, then arguments will be made when SCOTUS is in session. This is called a writ of certiorari. If the SCOTUS does not grant the writ of certiorari, then the appeals process is complete and the appellant no longer has any other appeal options. If the SCOTUS decides to hear the case, then it will review cases based on constitutionality. The court has a variety of different options available to them when they decide a case. They can choose to do nothing and allow the original decision to remain as it is. It can change part of the original decision. It can completely overturn and reverse the original decision, or they can decide that the case must be retried or the appellant must be resentenced. More commonly, an imprisoned defendant whose appeal has been denied may try to have the Supreme Court review his or her case on constitutional grounds by filing a writ of habeas corpus. A writ of habeas corpus is an order from a court to order an officer of the law to produce a prisoner in court to determine whether the prisoner is being legally detained or imprisoned. Moving away from the federal system and into the state system, we see that cases at the state level take a very similar path as those tried at the federal level. Some low-level criminal cases begin in the trial courts of limited jurisdiction and are usually referred to as the lower courts. The lower courts typically deal with minor cases such as ordinance and traffic violations. These cases often involve summary or bench trial and have no need for a full jury trial. Lower courts are not courts of record. An appeal from a lower court requires a trial de novo. That means an entirely new trial. A trial de novo is a trial in which an entire case is heard by a trial court of general jurisdiction because there is an appeal and there is no written transcript of the earlier proceeding. Other cases that are a bit more severe are funneled into the court of general jurisdiction. These courts have the authority to try all civil and criminal cases and also to hear appeals from lower courts. They are the courts of record. Some states have created specialty courts to deal with certain types of crimes or with chronic social problems. For example, we now have specialty courts that deal with drug issues, with mental health problems, collection courts, community courts, domestic violence courts, and of course, the newest specialty court, which deals with veterans. Once a defendant is found guilty, then he or she can appeal to the intermediate appellate courts. In these courts, some states have only one appellate court, the court of last resort, usually called the state Supreme Court. However, 39 other states have intermediate appellate courts to reduce the case burden on their individual state Supreme Courts. These appellate courts only hear appeals, no original cases. They review cases for errors of law. They cannot refuse to hear any legally appealed case. At the state Supreme Court level, in most states, the court of last resort is, of course, the state Supreme Court. The primary responsibility of state courts of last resort is to hear appeals from either original trial courts of general jurisdiction or intermediate appellate courts. After all of the state appeal options are completed, then the appellant can choose to petition the SCOTUS with a writ of certiorari like we previously discussed, provided that the appeal, of course, addresses a constitutional issue. Let's switch gears a little bit and focus on the individuals who are directly involved in the court process. Besides the defendant, we need a prosecutor who represents the state. We need a defense attorney who represents the defendant. And finally, we need a judge who leads and presides over all of the proceedings. Let's begin with the prosecutor. This is a representative of the state who chooses whether or not to charge a defendant, and more specifically, what to charge that individual with. The prosecutor works closely with law enforcement to put together the strongest case possible in order to prosecute and convict the defendant. But it doesn't always work that way. When a prosecutor elects not to prosecute, they enter a notation of nolle prosequi on the official record or the case and formally announce in court that the decision to dismiss the charge or charges has been made. Insufficient evidence is the most frequent reason given by prosecutors for not prosecuting cases. When do they choose to prosecute? Ideally, prosecutors are supposed to charge an offender with a crime, and they are supposed to prosecute the case if after a full investigation, 3 and only 3 conditions are met. First, they find that a crime has been committed. Second, a clear perpetrator can be identified. And finally, there is sufficient evidence to support a guilty verdict. On the other hand, prosecutors are not supposed to charge suspects with more criminal charges or for more serious crimes than can reasonably be supported by the evidence at hand. They also should not be deterred from prosecution because juries have refused to convict for certain types of crimes in the past. And finally, they should not prosecute simply because the public demands it. or they should not prosecute because of political repercussions that may come their way if they choose not to. Let's discuss the defense attorney for a minute. Defendants are allowed to have representation at all phases of the criminal process. This right is protected through the Sixth Amendment, and that protection begins once Miranda rights are read. A defendant may waive the right to counsel and appear on his or her own behalf, although it is not advised or suggested. In the American system of justice, the role of the defense counsel is to provide the best possible legal counsel and advocacy for the legal and ethical limits of the profession. All criminal defendants are entitled to an attorney, even if they cannot afford a private attorney. However, there are probable differences in the type of legal advocacy that you are receiving when you have a court-appointed attorney comparative to those who are able to hire someone for large amounts of money. The other issue is that most lawyers are not well trained in criminal defense. Many lawyers prefer to practice other, often more lucrative, areas of law. So even if I have a law degree, it does not mean that I should be the one to represent you in a criminal case. As I just stated, even though public defenders and retained attorneys provide the same function, the effectiveness of that representation is often very different. Watch the following video of Johnnie Cochran making his famous arguments in the O.J. Simpson trial. We all know the catchphrase, "If it doesn't fit, you must acquit," because of Cochran's skills as an attorney and because of his ability to make a strong argument.
I was thinking last night about this case and their theory and how it didn't make any sense and how it didn't fit and how something is wrong. And it occurred to me how they were going to come here and stand up here and tell you how O.J. Simpson was going to disguise himself. He was going to put on a knit cap and some dark clothes, and he was going to get in his white Bronco and this recognizable person and go over and kill his wife. That's what they want you to believe. That's how silly their argument is. And I said to myself, maybe I can demonstrate this graphically. Let me show you something. This is a knit cap. I'm going to put this knit cap on. And you've been seeing me for a year. If I put this knit cap on, who am I? I'm still Johnnie Cochran with a knit cap. And if you look at O.J. Simpson over there, and he has a rather large head, O.J. Simpson in a knit cap from 2 blocks away is still O.J. Simpson. It's no disguise. It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit. It reminded me that there was testimony early on that Detective Lang had refused basically to pick up a knit cap inside the Brown residence.
After watching this video, you can see that most successful criminal lawyers gain their reputation by their ability to fix cases. That is, they are able to get the best possible result through the use of plea bargaining, strategic uses of motions within the court, relationships with the prosecutor, or through the hearing before the right sort of judge. Most of these attorneys never earn the level of fame and notoriety that Johnnie Cochran has. Instead, some may never even see the inside of a courtroom. They are busy doing all of the behind-the-scenes work before the trial can even begin. A criminal lawyer's time is his or her most valuable commodity. Trials are all-consuming. Therefore, criminal lawyers often try to avoid trial. Some attorneys resort to unethical or illegal practices to ensure that they are paid for their services. In this slide, you will see the breakdown of states and how they fund public defenders. All states have a public defender program. They just differ on the ways in which the money is distributed. The federal system also has a public defenders program. Finally, we see that the judge, who might be arguably the most important actor in the courtroom. During trial arguments, judges often take a more passive role and allow the attorneys to battle things out before them. But judges have a very active role in a lot of the other court proceedings. They are the only ones who can do things like sign a warrant for an arrest, set a specific bail amount, and release defendants on bond. And also, they are the only ones who can sentence offenders to prison sentences. Judges in the United States share many characteristics. They are generally white, male, from upper middle class backgrounds. They are Protestant. They have better education than most citizens, and they are 50 years of age or older. They have generally practiced law before becoming judges. That is not a requirement, but it seems to be the most common legal background among judges. If we look at their qualifications and trainings, we see that in most jurisdictions, lower court judges are not required to be lawyers or possess any special training. However, nearly all states require that judges on appellate and trial courts of general jurisdiction be licensed attorneys. Because many judges do not have experience with criminal law or procedure, many states require them to attend judicial training seminars. Finally, to end the lecture, let's move through the actual trial process itself, beginning with the pretrial process. Even though our correctional system is overrun with offenders, they are still only a fraction of the amount of people who come in contact with the court system itself. This funneling process shows that of the hypothetical 1,000 felony crimes committed, only 30 individuals are actually incarcerated for those felonies. This is a low number that comes from low detection and low reporting, but also from plea bargaining. Increasingly large caseloads in the state and federal courts are requiring new management skills that enable the courts to process a large volume of civil and criminal cases as efficiently as possible. Case flow management has been called, quote, the conceptual heart of the judicial administration in the new millennium. Today, court administrators are being influenced by basic business principles. Because a lot of this chapter is a repeat of some of the topics covered in Chapter 1, I will not be rehashing everything in the trial process in this lecture. Instead, I will focus on the items that we haven't covered yet. Looking at plea bargaining, the bargaining of a prosecutor will generally strike depends on three factors. First, it depends on the seriousness of the offense. Second, on the defendant's criminal record. And finally, on the strength of the prosecutor's case. There is neither a constitutional basis nor a statutory basis for plea bargaining. Plea bargaining developed out of custom, but it has been upheld by the Supreme Court ever since. It is widely used because of several factors. First, it is used because it reduces uncertainty in the criminal justice process. It also serves the interest of all the participants involved. Prosecutors are able to get high conviction rates. Judges are able to reduce their caseload. Defense attorneys are able to spend less time on each case and avoid expensive trials. And finally, defendants often get lighter sentences than they might have gotten from juries and can avoid conviction on stigmatizing crime such as sex crimes and child abuse. Two types of criminal defendants are not served by plea bargaining. First, innocent, indigent, highly visible defendants who fear being found guilty of crimes they did not commit are much more likely to plea bargain out. And secondly, habitual offenders. Prosecutors often use three strikes laws as bargaining chips to force repeat offenders into accepting guilty pleas. The majority of cases, roughly 95%, are resolved through the plea bargaining process. Of the remaining 5%, these cases are taken to trial either through a bench or through a jury trial. In a jury trial, a jury of one's peers make a determination regarding the guilt of the defendant. In a bench trial, there is no jury, but instead the judge is the individual to make that determination of guilt. Juries are used in order to make sure that no one individual runs away with all of the power of the court system. Instead, there are a number of individuals making that decision. Then they should theoretically be able to keep things fair and even across the board. However, the term peer has not always meant exactly that, and there have been historical accounts of juries and prosecutors not being very inclusive when it comes to gender or to race. The other issue that arises comes from the selection pool of potential jurors. Jury pools are often drawn from voter rolls, which exclude people who are not registered to vote, often including the poor, the poorly educated, the young, and minority individuals. Today, some jurisdictions use multiple source lists for obtaining jurors and don't rely solely on voter registration rolls. Traditionally, a jury in a criminal trial consists of 12 citizens plus 1 or 2 alternates who will replace any juror unable to continue on with the trial. More recently, primarily due to reduction in expenses, some states have gone to 6, 7, and 8-member juries in non-capital crimes. For capital offenses, the state still requires that 12 citizens serve on the jury. On the day of jury selection, all eligible individuals who received a jury summons must appear for the voir dire. During voir dire, the jurors are selected from a jury pool, which is called the veneer. From the veneer, or the jury pool, as many as 30 people are randomly selected by the Court of Clerk for the jury panel from which the actual trial jury is selected. Potential jurors go through voir dire, during which the defense, prosecution, and judge question the jurors about their background and their knowledge of the current case. Potential jurors can be eliminated by either the defense or the prosecution in 2 ways. First, they can be eliminated for cause. This means that the juror appears to be biased or unable to render a fair verdict against the defendant. And secondly, the defense or the prosecution can eliminate a potential juror by use of a preemptory challenge. This means that the juror will be excused without either side having to provide a reason for that excuse. Even though the defendant is the one on trial, the prosecution has to prove that the defendant is guilty. The defendant does not have to prove that he or she is not guilty, although most defendants do supply arguments in support of a not guilty verdict. If the defense feels that the prosecution has not made its case, it can rest and ask for a directed verdict or make a motion for dismissal. If the case is not dismissed and the defendant at this point is not acquitted, then the defense presents its case. Before a criminal trial formally begins, attorneys in about 10% of felony cases file pretrial motions. Common pretrial motions ask for discovery of evidence or the suppression of evidence at the trial. These don't often occur, and the trial continues on, as we will see in the next slide. This slide is a good representation of the trial process winding its way from the beginning of the trial all the way through the verdict. As you will see, the evidence is collected, charges are filed, and both parties head to court for the actual trial. Both the prosecutor and the defense team have the opportunity to open the trial with a statement summarizing the arguments that they will make during their cases. The prosecutor always presents his or her case first to show why the defendant is guilty. The defense team follows and is given the opportunity to debunk the prosecutor's claims in their own arguments about why the defendant is not guilty. The prosecutor is then given at least one more opportunity to counter the defense team before both sides are allowed to make their closing arguments, which summarize their cases. Finally, in the last stages of the trial, the jury makes a decision regarding the guilt of the defendant. In the last part of the trial, the jury makes a decision whether the defendant is guilty or not. The jury is given instructions from the judge focusing on what can be considered, what cannot be considered, and the requirements for the specific charge. If there is a guilty verdict, then a sentencing is scheduled. If the jury cannot agree beyond a reasonable doubt that the defendant has committed a crime, it must acquit. If the jury cannot reach a unanimous verdict, then the result is a hung jury. A hung jury results when the jurors cannot agree on a specific verdict. The judge can encourage the jury to try one more time to come to a decision, and if they still cannot come to a unanimous decision, then the judge must declare a mistrial. The prosecutor then must decide whether or not it is worth it to retry the case. If you are interested in seeing how the jury deliberation process takes place, please watch the film 12 Angry Men, which was produced in 1957 and stars Henry Fonda. In conclusion, this lecture we learned about the courts and how they handle criminal cases at the state and federal levels, as well as during the appeals process. We also had a brief overview of the key actors involved in the trial, as well as the trial process itself from the beginning to the end. Although this is a brief review of the items, it gives you a good insight into how trials work. You will learn more about these items in future criminal justice classes. Thank you for listening and paying attention. Please see your syllabus for the next lecture in the series. I will see you all next time. Have a good day. Goodbye.